Welcome to Rock Center Shorts. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. In my role, I oversee Stanford's Foreign Corrupt Practices Act Clearinghouse, which was developed in collaboration with Sullivan and Cromwell, and which tracks FCPA-related investigations and enforcement actions initiated by the SEC and the DOJ. That is relevant because today we're going to talk about the Trump administration's executive order pausing enforcement of the FCPA, what that means for FCPA enforcement going forward, and how companies should respond to changing enforcement priorities. I'm joined today by Laura Oswell, a partner in the litigation group at Sullivan and Cromwell, and Aisling O'Shea, who is co-head of the FCPA and anti-corruption group and a member of the criminal defense and investigations group and the litigation group at Sullivan and Cromwell. Welcome, Laura and Aisling.
Thank you.
On February 10th, the White House issued an executive order that was titled Pausing Foreign Corrupt Practices Act Enforcement to Further American Economic and National Security. Aisling, can you give us a high-level overview of what the executive order says, and then we will dive into each of the directives in more detail?
Sure. So at a high level, the executive order directs the Attorney General to conduct a 6-month review of the guidelines and policies surrounding FCPA investigations and DOJ enforcement actions. During the initial review period, which can be extended for another 6 months, the DOJ is directed to cease all new FCPA investigations and enforcement actions unless specifically authorized by the Attorney General, to review all existing FCPA investigations and enforcement actions, and then to issue updated guidelines or policies that govern both FCPA investigations and enforcement actions. And then once the revised guidelines are issued, the Attorney General is directed to assess whether remedial measures are appropriate regarding inappropriate past FCPA action.
Great. All right, Aisling, as you noted, the executive order directs the Department of Justice to cease initiation of new FCPA investigations or enforcement actions unless authorized by the Attorney General. To date, Laura, have any exceptions been made? In other words, has the department announced any new FCPA investigations or enforcement actions since the executive order was signed?
We have not heard about any new investigations or enforcement actions in this space since the executive order a couple of months ago. And to be honest, we wouldn't be surprised if things stay quiet during the period of review that Aisling just described. As you know, these investigations are usually multi-year endeavors. So unless there's something truly urgent that comes up within the scope of the administration's priorities, I don't think we're expecting to see much activity while this review is underway. I think it's also important to keep in mind that these statutes are subject to a 5-year statute of limitations. So the government has quite a while to determine, whether or not to take action, and wouldn't expect to see any sort of action here in the meantime. In terms of how this impacts the disclosure analysis for companies, I think it's pretty clear that companies will be well served to wait to see how the disclosure, how the guidance comes out, what might be, new or different, how that might impact their calculus. At the same time, we're not counseling kind of any difference in approach, but as we know that self-disclosure question is one that is always very complicated, very fact intensive, a tough strategic decision. And so while we're in this period of review, there's probably going to be some, companies that choose to wait to see what the guidance says before they make a final call.
And if I could just add to that, Laura, even if you're making the determination that now is not the right time to self-disclose what might be a potential FCPA matter, companies should still, especially because of the statute of limitations that Laura noted, which is also extendable by up to 3 years if the DOJ makes requests for foreign evidence, companies should take all of the preservation, investigative, and remedial steps that they would otherwise deem appropriate, so that if there is a day when the DOJ comes knocking, companies are able to share a compelling narrative about the appropriate steps that they took in response to a potential issue, even if they opted not to self-disclose it at the time.
Absolutely.
That's good advice. Aisling, let's talk about investigations and enforcement actions that were already underway but not yet resolved at the time the executive order was released. So that could include instances where the SEC or DOJ had already initiated a formal investigation, where the government had secured an indictment or filed formal charges, but the matter was still pending. What do we know to date about these ongoing actions and investigations, and what do you expect to see in the coming months?
Sure. So in terms of cases that have already been charged by the DOJ, one has been dismissed. One, it was just announced, I guess, 2 days ago, the prosecution will move forward. And there are a couple of others that would have otherwise been at their trial dates. And the government has requested more time in connection with the ongoing review. So we'll have to stay tuned on the outcome of those cases. Some companies that had previously disclosed FCPA-related investigations have updated their disclosures to reflect that those investigations have been closed. Whether that's in connection with the ongoing review or not remains uncertain. And then I guess finally, while not directly in connection with the ongoing review, at least publicly, it is noteworthy that Glencore's monitor, which was appointed in connection with its FCPA resolution, the monitorship was terminated early.
Good. I'm glad you brought that up, and I do want to talk about monitorships a little bit more in a few minutes. But just to follow up on that, Aisling, in light of the executive order, what advice would you give to individuals or companies that are subject to a pending FCPA investigation or enforcement action?
So I think it's not going to be a one-size-fits-all answer, because there may be cases, both individual cases and corporate cases, where the best thing to do is just let it ride, take advantage of the slow period, and then hope that your case is going to be among those that go away. I think that there are other cases where individuals, for example, if you had an individual that was currently incarcerated, you would not decide to see how the review comes out and hope that it's in your client's favor, right? If you're a company that has been subject to an investigation for a long time, perhaps it's been very expensive. If you think you're at a good inflection point to try to press for answers now, and there is an advantage to doing it, we're hearing that companies are doing that. But I think it really depends on where you are in the matter, and whether just allowing the pause to wend its way through the process is more advantageous, or whether trying to push for an answer from the DOJ right now is more advantageous. But I don't think there's a one-size-fits-all approach.
Laura, anything to add?
No, I think that's exactly right. It really will depend on the facts and circumstances that your client finds himself in, and kind of the immediacy of the problem, I would say.
The executive order directs the Attorney General to determine whether additional actions, including remedial measures with respect to inappropriate past FCPA investigations and enforcement actions, should be taken by the DOJ or recommended to the President. This is pretty vague language, but Laura, do you have a sense of what types of additional actions or remedial measures the White House has in mind? And to your knowledge, has the department taken any action in line with this directive? And this might loop back to what Aisling had mentioned.
I was going to say, I think the clearest example that we have, or certainly something I would think of in this category, is the termination of the Glencore monitorship earlier, in the sense that the company had, signed up and agreed to a monitorship for a certain period and got some relief on that period. Other than that one action, I don't think we've seen yet. We don't know for certain. It probably will be tied to how the guidance comes out, kind of where the administration decides to focus its priorities in terms of enforcement, and how the past actions and past enforcements have line up with those priorities. I mean, we've seen in other areas, the administration take action, in areas where it's decided maybe past enforcement approaches or priorities were not aligned with the administration's current priorities. This goes all the way up to presidential pardons that we've seen in other white collar matters. But it's difficult to predict what all companies might be able to avail themselves of, as this evolves.
How would you advise companies that have ongoing compliance obligations and monitorship stemming from an earlier resolution in the FCPA context, of course?
I think, as in all cases, this is a very fact-dependent inquiry, kind of where the company sits in its process. But I would imagine that all companies that are subject to enforcement actions and ongoing obligations of those sorts will be taking a look at and thinking about how they can best position themselves if there's an opportunity to have the same sort of relief that Glencore received. How do you best do that? I think one thing that we think about is making sure that if you're under a compliance obligation, you can make the case that the government's enforcement action has already served its purpose because the company has already completed the reforms that it's obligated to complete. That in the monitorship context, the company has already essentially done the work that's necessary that led to the imposition of a monitor in the first place. I think those are the things that are really within the company's control at this point in time, if they're thinking about how to open that discussion with the government.
Mm-hmm. The executive order also directs the Department of Justice to conduct a review and issue revised enforcement guidelines for the FCPA. No guidelines have been released as of today, which is April 11th, 2025. But Ashley, do you have a sense of what those guidelines will look like?
I don't think any of us have a real sense of what those guidelines are going to look like, but I think based on the fact that the executive order refers both to how investigations are conducted and to enforcement actions, there are likely to be both the substantive elements of what are the parameters of FCPA enforcement going to be going forward, but perhaps also some procedural elements of how FCPA investigations should be conducted.
There was a memo issued by the Attorney General in February that outlines, among other things, FCPA priorities. Can you talk a little bit about that memo and how it relates to what we might see in FCPA enforcement moving forward?
Sure. So just a couple of days before the executive order, Attorney General Bondi had issued a memo that mentioned that FCPA enforcement should be focused on matters that involved transnational criminal organizations, cartels, smuggling, and human trafficking. Those are perhaps hints as to some substantive elements of the guidelines that will be issued in terms of areas of potential focus in future FCPA investigations and enforcement actions. But I do think it's important to keep in mind that the executive order does not reference the Attorney General's memo at all. The two documents are not in conversation with one another, so it's difficult to make a prediction as to whether and how they're going to overlay.
Going to throw out a hypothetical for you here. So if the guidelines did comport with what we've seen in the Bondi memo and the DOJ now prioritizes FCPA cases with a nexus to cartels and transnational criminal organizations, what would we expect to see in terms of FCPA enforcement in the coming years, and what types of companies would likely end up in the crosshairs?
So I actually think it's much broader than we would guess. I don't think I could say what types of companies are most likely to be impacted because, first of all, the definition of transnational criminal organization is incredibly broad. And second of all, I think that we've seen that in a number of countries, corruption has been linked to many of these concepts that are expressed in the AG's memo, including cartels, smuggling, human trafficking, and transnational criminal organizations. So I think the points of intersection are wider than we would expect. And if prosecutors are directed to go and look for those links, I don't actually think right now we could make definitive predictions about where they're going to be most likely to find them.
That's fair. All right. Ashley, one more for you here. The DOJ and SEC share responsibility for enforcing the FCPA. What do we know about how the executive order will impact the SEC's FCPA enforcement practices?
Sure. So as you noted, the executive order only explicitly references the DOJ. The only public statement that I'm aware of coming out of anyone in the SEC staff is a statement that the SEC intended to follow the DOJ's lead. And we are hearing that practically speaking, the SEC appears to be pausing the same way the DOJ is.
All right, Laura, how are other authorities that prosecute transnational bribery responding to the executive order? And do you think these authorities will step in to fill the void that's left by the United States?
Well, I think this is an interesting question because one of the features of FCPA enforcement that we've noticed out over the last 10 to 15 years in particular is the proliferation of anti-bribery laws kind of around the world. It used to be primarily a US matter, and then we saw the UK jump in, and now there are a number of countries throughout the world that are actively enforcing their own anti-bribery statutes. And while it's too early to predict how this might impact enforcement around the world, I think there are a couple of notable developments. One is, last month, regulators from the UK, France, and Switzerland announced the creation of what they called an international anti-corruption prosecutorial task force. I think this is really a formalization and a public statement about something that we've known is going on for a long time in terms of informal cooperation. But at least as this was announced, it was meant to be something more systematic, and the creation of a leaders group to work on strategy and a working group to really focus on matter level cooperation. And I think that that's an interesting statement that at least suggests some countries are thinking about how they might become maybe even more active or more publicly active in this space. Other countries might take, different approaches, but it's not the case. And I think this will feed in to some of the guidance that we'll talk about for companies. It's not the case that suddenly anti-corruption laws are a thing of the past or are suddenly much narrower across the board. As companies have been, they face these sorts of regulations and requirements from all over the world and, have to deal with things in multiple different jurisdictions. I think on a smaller scale and closer to home here in California, I think it was just yesterday, the California Attorney General announced that, they view their powers under California's very broad unfair competition laws to be sufficient to prosecute from California violations of bribery or bribery violations. And I think that's an interesting take. We've seen, in a number of different realms, California, but also other states step in where they believe the federal government's enforcement is lax or contrary to their priorities. This is definitely a far more international take on that sort of state assertion of power that we've seen. But I think it'll be very interesting to see how that plays out as time goes on.
Do you think other attorneys general will follow suit?
I think it'll be interesting to see. I think we need to see a little bit more about how California, chooses to exercise that power as a practical matter. Our statutes here are known to be very broad. We're also known to have amongst the more active attorney general's offices. But, it's tough to say. You could definitely see other states following suit.
All right, Ashling. Foreign bribery is often prosecuted through laws that are adjacent to the FCPA, like money laundering, wire fraud, even securities fraud. Do you think more cases that would have historically been brought under the FCPA will now be brought under related statutes, or do you expect to see a drop in FCPA adjacent actions as well?
So as with all things, I think we're not really sure. And I think a lot is going to depend on the nature of the guidance that comes out. One feature of the Bondi memo that came a few days before the executive order is it removed the requirement that otherwise exists in the Justice Manual, directing that all FCPA investigations and prosecutions have to be conducted through the FCPA unit where it related to those priorities of cartels, smuggling, human trafficking, and transnational criminal organizations. So if there is a decentralization, which I think is consistent with some other rumblings we're hearing of DOJ policies from the FCPA unit in the criminal division out to the U.S. attorney's offices, there may be a certain amount of unpredictability as to when somebody is going to charge not necessarily the FCPA, but as you note, money laundering within FCPA specified unlawful activity under a component, or a violation of the Travel Act, where to Laura's theme, there was a violation of a state anti-bribery statute involving travel or the use of means and instrumentalities of interstate commerce. And it's going to depend on how broadly substantive the directive is. Is it talking about, as you said, foreign bribery related conduct, or is it talking specifically about the Foreign Corrupt Practices Act of 1977? But I think, and I know we keep foreshadowing this, when you're thinking about how to advise companies and individuals, it is really critical to consider that conduct that violates the FCPA may also violate any number of other federal, state, and international laws. One other thing that's just worth noting when we're thinking about other statutes is the Foreign Extortion Prevention Act, FCPA, which is also not explicitly addressed in the executive order. It's our understanding that generally FCPA cases are, practically speaking, being paused. But if the president's focus is on protecting US companies, you could see this administration ultimately deciding that FCPA, which provides the United States with a direct tool against the so-called demand side of bribery, is an area where enforcement ultimately should ramp up.
That makes sense. And I will just add one thing, which is the bonding memo also directs the Department of Justice's money laundering and asset recovery sections to prioritize investigations that target activities of cartels and transnational criminal organizations, similar to the language that relates to the FCPA. So I suppose we could see a similar adjustment in enforcement priorities there, but we'll have to wait and see. All right, so let's get to the meaty question here. So over the past few decades, companies have spent considerable time and resources building and implementing FCPA compliance programs. And I know the question that's top of mind for many of these companies in the wake of the executive order is whether they should make any changes to these programs or whether they should stay the course. So what are you advising your clients? And Laura, let's start with you.
Yeah, I think the long story short is that staying the course is the way to go here for several reasons. One, at least until we have some guidance as to what, the new direction is going to be. But even not knowing what that guidance might be specifically, we think companies are much better served to maintain rigorous compliance in this area. I think that there are, a few reasons for this. First, as we've said before, there are multiple different ways to approach the same sort of conduct, and that can come not only from the United States federal government, but from state authorities and from international authorities. And so a lot of companies' compliance programs are designed to solve for multiple different problems. And so the change, whatever change we might see in the enforcement of the FCPA, won't really impact probably all of the different things that companies' compliance programs are designed to address, even just in the anti-corruption space. In addition to that, I think the practical view is that, companies will always be well served if they find themselves with an issue because of a rogue employee or a company that they acquire, things that they could not reasonably otherwise control if they have those strong controls and compliance functions. And so I think it only harms a company's kind of long-term ability to protect itself in any kind of legal regime or set of priorities to be able to say, as an organization, we set up the right structures to do the right things in the jurisdictions where we operate, and that we did not wind those things back at a moment where maybe certain enforcement priorities changed. I think in the long run, that's always going to be the best move for the company. I think it's also important to note, just as a final point, I think we said this before, there's a long statute of limitation for these statutes. The FCPA is 5 years, which, as Aisling said, could be extended for 3 years in certain circumstances. And so it would be a risky proposition for many companies to try to make some drastic change in their approach to compliance, counting on some limited enforcement priorities with respect to the FCPA.
Aisling, anything to add?
I think Laura really got to the heart of the issue. And so without taking away from that, one other practical consideration is there must be trillions of dollars worth of contracts worldwide that have reps and warranties related to, one, compliance with the FCPA, and two, whether companies have FCPA and anti-corruption compliance programs. So even putting aside that enforcement priorities can change and the statute is long, there's all kinds of laws, there's international enforcement. If companies look, they could be subject to massive amounts of civil litigation if they decide to abandon FCPA compliance efforts, because the FCPA remains the law. And I've never looked at a contract that says we represent that we are in compliance with the Foreign Corrupt Practices Act unless it's determined to not enforce it for a little while. So I think there are a lot of considerations, both in terms of risk management, practicality, sustainability, fostering a culture of compliance, why staying the course is really the essential thing to do.
There's also just a real risk that loosening the reins on anti-bribery policies could lead to less rigorous compliance in other areas as well. So definitely agree with you there. Last question for the two of you. What do you think this pause and possibly more permanent rollback in FCPA enforcement will mean for U.S. companies that operate abroad? Is this a welcome development that levels the playing field and makes U.S. firms more competitive, as the executive order suggests? Or does this rollback instead have the potential to hurt American businesses? And Ashley, why don't we start with you?
Sure. So for me, one aspect of the executive order that's very interesting is if you look at the stated policy goals of it, including, as you note, the potential disadvantaging of U.S. companies, foreign policy and national security interests. If you look at the legislative history of the Foreign Corrupt Practices Act, those are the same justifications for enacting the statute to begin with. So it's very interesting. You take this question of what provides U.S. companies with an economic and competitive advantage or disadvantage. In 1977, that question was answered in part through the enactment of the FCPA. In 2025, the question is being answered, at least by the president's executive order, in a completely different way. But when you look at the themes of the executive order, they're the same themes that were at issue when the FCPA was first enacted. They're just using the same themes and concerns to come to different conclusions from a policy perspective.
Great. Well, Laura and Aisling, thank you so much for joining me today.